This Honorable Court of Tennessee is now in session.
Good afternoon. This is the April session of the Court of Criminal Appeals in Knoxville. The panel today is Judge Ross Dyer from Memphis, Judge Tim Easter from Franklin, and I am Norma McGee Ogle. I'm from Sevierville. Now, understand that you want to divide your arguments, the defendants. So could you let me know exactly how you plan to do that?
Yes, ma'am. Your Honor, I'd like to reserve 5 minutes for rebuttal, and I will argue the first two issues in the brief and take 7 minutes, and Mr. Working will argue the remaining issues in the brief with the remaining 8 minutes, if that pleases the court.
All right. We are ready to call the first case.
State of Tennessee versus Deborah Morton.
Good afternoon, Judge Ogle, Judge Dyer, and Judge Easter. I'm Valerie Corder, and I and my co-counsel Michael Working represent the defendant, Deborah Morton. Ms. Morton was convicted of the first-degree murder of her husband, Floyd Morton. There are several Mortons involved in this case, and if it pleases the court, I prefer to refer to the victim as Floyd so we can keep him separate from the other Mortons involved. We mean no disrespect by this, we just are trying to keep focused. Ms. Morton and Mr. Morton had been married for 30 years when she found him on the sofa, bleeding from a bullet wound, but still alive. Mr. Morton was morbidly obese, had cardiac problems, had high blood pressure, had diabetes, he had obstructive sleep apnea, he had kidney stones and kidney disease, and he was not a well man. Despite the condition of his health, the state attempted to prove their case not by the evidence, but by allowing the jury to hear what his friends believed to be his state of mind, to try and establish that he did not commit suicide. Now, interestingly enough, none of the state's witnesses ever asked Floyd if he was depressed. None of them ever asked him if he was in pain. They simply ventured their opinions of his state of mind. This evidentiary error is rather apparent when one considers the wording, specific wording of Rule 803 of the Rules of Evidence. One is not permitted to include a statement of memory or belief to a fact remembered or a fact believed. And yet 11 witnesses for the state expressed their belief of Floyd's state of mind. This included the state's lead detective, Patrick Upton, Lieutenant Patrick Upton, expressing the opinion of some co-workers and golfing friends of Mr. Morton, of Floyd Morton, that their opinion was that he wouldn't have killed himself, that he wasn't depressed, he wasn't in pain. This is the kind of hearsay that was impossible to cross-examine for Deborah Morton. It violated her rights of confrontation. It certainly violated her right of confrontation for people who never asked the decedent how he felt or whether he was suicidal or depressed about his condition, what his condition actually was. In fact, the state set up this confusion as to what was Floyd's condition because it never subpoenaed his medical records. It never collected from his home the prescription bottles containing his medications for all of the illnesses I described. But most significantly, it did not collect his antidepressant medication. The evidence at trial was that Floyd had stopped taking his citalopram, which was his antidepressant medication, 6 to 9 weeks prior to his death. Now, these lay witnesses didn't know that. They didn't know that Floyd had a strong family history of bipolar disorder and depression. They'd never asked him how he felt or whether he was depressed after his reconstructive knee surgeries. And to enhance the appearance that Mr. Morton, Floyd Morton, had not killed himself, the state's main witness, Lieutenant Upton, flat out perjured himself as to the location of the bullet wound. Lieutenant Upton, as we recite in the brief, gave 8 different locations for the entry wound of the bullet that killed Floyd Morton. Most of these were in the back of his head somewhere. He did so, as he stated under oath, because it would have been impossible for Floyd to have maneuvered the weapon to the back of his head. However, the autopsy report is absolutely clear. The bullet wound was to Mr. Morton's left temple. Mr. Morton was the only person who had gunshot residue on his palm, back of his hand, and on his fingers. These facts were not allowed to be expressed to the jury through witnesses. The state objected to the presentation of 3 expert witnesses, one of whom was an expert in suicidal risk assessment and was a psychiatrist who's testified for the state in that exact issue. In State versus Moses Bess, I believe it was an opinion that Judge Dyer wrote, Dr. Alexander was certified as qualified expert witness in psychiatry and risk assessment. In the case of Deborah Morton, he was not permitted to testify to the risk factors. He found that Floyd had 9 of 10 risk factors favoring suicide and only 4 protective factors antithetical to suicide. The opinion of the trial court as to the exclusion of this witness cites the speculative nature of determining what somebody was thinking as to whether or not they would commit suicide. And this is the exact same objection that the defense had to the lay witnesses who said, oh, no, Floyd was Christian. Floyd's belief system, he would have gone to hell. So we can't find that he committed suicide. It was easier for them to believe that he had been murdered so that they didn't have to picture their friend in hell. In addition to excluding the testimony of Dr. Alexander, the trial court severely truncated and limited the testimony of Dr. Valentine, who was a pharmacologist, and Dr. Orthoffer, who was an internist. Both of these experts would have testified to the antidepressant medications that Floyd was prescribed and had stopped of his own taking, the risk of serotonin crashing from not withdrawing properly from an antidepressant medication. They could have testified to his high blood pressure meds, his pain meds, and that he was, in fact, terminally ill and very depressed. These issues, the issue of Dr. Alexander's exclusion is an issue of first impression before this court. Would the court allow a psychiatric autopsy to be performed on the decedent? In the Moses Best case, to which I referred a moment ago, this exact same witness testified to a psychiatric autopsy of the victim and concluded that she had not killed herself. However, this jury was never allowed to hear this. In addition to the jury's restriction from hearing the confrontation of these lay witnesses, the jury, Ms. Morton, was denied the right to confront. She was also denied the right to put on her defense by not being permitted to put on the psychiatric testimony from Dr. Alexander. Thank you. I think my time is up.
Thank you.
May it please the court, I'm Michael Working, and good afternoon to you all. I cannot express how devastated I am to be in my conference room and not in one of the most beautiful courtrooms I've ever seen, but maybe next time. I will address the issues of sufficiency, prosecutorial misconduct, and cumulative error. Rarely, frankly, do I ever argue sufficiency of the evidence. This is a massive record, and there's an absolute paucity of evidence of any kind of murder. Certainly not one involving Deborah Morton. The defense in this case was prevented from impeaching Floyd Morton's brother, Robert, who lived downstairs, was a sex offender who was on parole, and they were prevented from impeaching him or effectively putting out any proof to him. He had gunpowder on him. He stated that he was not awakened by police sirens. One of the most important pieces of evidence in this case is that first responders arrived at the scene and Deborah Morton is rendering first aid to her husband per the instructions of the 911 operator. There's absolutely no direct evidence, and there's really no circumstantial evidence of murder whatsoever. The circumstantial evidence that the state uses is an intent to negate suicide, because even the medical examiner himself could not say that this was a homicide. Again, the proof became about whether Floyd killed himself, and Floyd had gunshot residue on his left hand, on his palm, on the back of his hand, and his fingers. The case became about trying to rebut circumstantial evidence by saying things like people don't commit suicide with their offhand. And the medical examiner disagreed. He said, I've seen plenty of those. They don't place something to muzzle or muffle the sound of the shot between them. In this case, a pillow. And the medical examiner said, I disagree. I've seen that plenty of times. So the state's case was not any affirmative proof or even circumstantial proof that Deborah Morton committed a crime against her husband. It was all an attempt to prove that Floyd Morton did not kill himself. And that's an important distinction, because even if the court were to say there's enough evidence of murder, there is none against Deborah Morton. In this case, the prosecution failed to correct false statements in the search warrant for over 3.5 years that said that they were searching Ms. Morton's computers for evidence of being a sexual predator in things that were released into the paper, sex offense evidence. There was, for 3.5 years, they made statements into the public that there was evidence that she had researched death benefits in order to financially benefit from her husband's death, which was an absolutely false statement that they failed to correct for 3.5 years. In fact, they attempted to withdraw money to support their college education of their daughter. It was a form to make a voluntary withdrawal from a 401k to pay for college expenses. The state in this case failed to correct obviously false testimony from the lead investigator, Lieutenant Upton. He testified on several occasions that Mr. Morton, Floyd Morton, had no health conditions, no health. It was the picture of perfect health when he had about 12 or 13 comorbid illnesses. He testified to 8 different places of the gunshot wound. Said it could not be in the back, could not be in all these places, and said it was in his left temple. And the medical examiner said this could absolutely be a suicide. But in addition to objecting to any piece of evidence the defense ever tried to put in, even if it had been evidence that the state had been allowed to put in prior cases like Best, the prosecution in this case had a habit of obstreperous objections after the defense won jury out hearings. Most concerning when the daughter of Floyd and Deborah Morton is testifying. I mean, that's really compelling testimony. And when the trial court allows her to testify in jury out hearings, the state objects 9 times in 12 minutes after the jury out ruling in favor of the defense. The jury is sent back out of the room, and then when the defense is granted the ruling again, the state objects 15 times in 12 minutes. Throughout the trial, the state objects constantly without ever even stating a basis for the objection. It appears purely to harass and intimidate the defense. And without stating any objection over and over and over, the trial court sustains most of it, which brings me to my final issue of cumulative error. In this case, to exclude the experts, which we've argued is a Sixth Amendment violation, preventing Ms. Morton from having a defense, the court invented a fictional legal standard, stating that evidence of suicide would be prejudicial to the jury, as if that is any standard in Tennessee. It's not recognized in any state that I know of, or the federal judiciary. Prejudice to the jury, as if it's too much for the jury to consider suicide. Cumulative error is granted in cases where the proof is pretty thin, it's in direct proportion, the harmless error is lowered and the prejudicial inference increases when there's less proof of any guilt beyond a reasonable doubt. And that's certainly the case here. In this case, from pretrial, hundreds of pages, the trial court consistently ruled against the defense on everything, ruled that the state had no duty to preserve evidence, ruled against the defense for the state failing to preserve body cams and dash cam evidence of what happened at the scene while Miss Morton was rendering first aid. It excluded all defense experts. It included opinion from the state and lay witnesses, often third party through the lead detective who did not testify, from witnesses who did not testify, just the detective. They allowed improper opinion from the lead detective. They ruled that they could the state attacked the defendant's character in their case in chief improperly. It sustained objections over and over from the state that the defense could not attack the police investigation. It allowed the 24 objections in 24 minutes. And it just amounted to cumulative error that prevents an unfair trial. I would say as a last thing to the court, as my time is probably drawing near.
You have about 1 minute left.
Okay, thank you. Both Mr. Mortons, Floyd Morton, Bobby Morton, both had gunshot residue on them. And as the experts testified, there are 3 different chemicals required to be able to give us an opinion that there's gunshot residue on a person. Miss Morton, who rendered aid, had one of the chemicals that was argued to be from a transference. She did not have all 3 chemicals on her required for gunshot residue. And then she sat with the sheriff, the elected sheriff of Loudoun County, in the kitchen, who happened to be Floyd Morton's best friend, for an hour and a half, praying together. The state argued that she destroyed evidence by throwing out this couch that was covered in his gore that no person would keep. The state argued that she somehow, destroyed evidence by washing her hands after praying with the sheriff for an hour and a half. At no point, anything that Miss Morton did was bad faith. Any failure to preserve evidence or not test her hands is completely the responsibility of the state. But there has been a miscarriage of justice in this case, frankly. At every turn that Miss Morton could have an unfavorable ruling, the trial court granted that unfavorable ruling in favor of the state. And so for the reasons that I've argued today, I'd ask that you reverse this case, reverse this verdict. Frankly, I'd ask that you rule there's no sufficiency of the evidence to sustain this conviction, so that she's acquitted of these charges. Thank you very much for your time.
Thank you, Mr. Wood. General Brandon.
Your Honors, and may it please the Court, Cody Brandon for the State of Tennessee. We'd respectfully request that this Court affirm the judgment of the trial court. I do want to begin preliminarily with a correction to the State's brief on pages 45 and 46. We've argued or stated that defendant didn't object to testimony from Carol Williams. Defendant did object to that testimony in a jury out hearing, as defendant pointed out in her brief, and I appreciate the correction on volume 45, pages 1647 through 48 of the record. Defendant did object to that testimony in a jury out hearing. So I did want to correct that error for the court. The state does maintain its other waiver arguments in that section, and if this court decides against us on waiver, would obviously press the merits of the issue. But that correction aside, I'll start by addressing the limitation of defendant's expert testimony. Their defendant attempted to present 3 experts at trial, and the trial court held a McDaniel's hearing before trial to determine the scope of that testimony. And with each of these experts, the trial court appropriately limited the expert's testimony to their scope of expertise. And so Dr. Valentine was an expert in pharmacology. What the trial court ruled is that As an expert in pharmacology, he was qualified and allowed to testify about the types of medications prescribed to Floyd and the effects that those medications would have on him and that they would have if he stopped taking them. But the trial court ruled that Dr. Valentine could not go as far as to diagnose depression in Floyd, and that was not an abuse of discretion because Dr. Valentine admitted that he was unqualified to diagnose depression. He lacked that medical qualification. He never interacted with Floyd, and he did not interview any of Floyd's relatives or friends. With respect to Dr. Orthofer, the trial court, again, appropriately limited that testimony to Dr. Orthofer's area of expertise. Dr. Orthofer was an expert in hospital medicine, so the trial court allowed him to testify about the conditions that were diagnosed and documented in Floyd's medical records and explain what those conditions were, how they would have affected Floyd's body, and what he may have felt as a result of those conditions. But the trial court stopped Dr. Orthofer from testifying about was a postmortem diagnosis of Cushing's disease or a risk for suicide, both of which Dr. Orthofer was unqualified to testify about. Dr. Orthofer, again, admitted that he was not medically qualified to give an opinion on the risk of suicide without understanding Floyd's psyche, and he could not do that because Floyd was dead. And he also admitted that he could not diagnose Cushing's disease post-mortem. The best that he could give the trial court was that maybe there was a distinct possibility that Floyd had Cushing's disease. And so the trial court appropriately exercised its role as the gatekeeper, drew the line between where these expert testimony crossed from their realm of expertise into speculation that was unhelpful to the jury. The third expert, Dr. Alexander, the trial court, again, limited his testimony. He ended up not being presented at trial, but the trial court ruled that he could not present the conclusions of his psychiatric autopsy. And looking under the McDaniels factors, that decision was correct by the trial court. The court looks at 5 factors under McDaniels to determine whether especially new scientific evidence ought to be admitted, and all 5 of those factors weighed against admission of the psychiatric autopsy. There was no tested methodology for Dr. Alexander's psychiatric autopsy. Dr. Alexander testified that he essentially cobbled together standards from the American Psychological Association and the American Psychiatric Association to create a new approach that wasn't accepted by either. The peer review and publication factor actually indicated that psychiatric autopsies weren't reliable for court. Dr. Alexander testified that he adopted part of his methodology from a published article, part 1 of a published article, and part 2 of that article actually listed out 6 limitations on psychiatric autopsies and indicated that because of those limitations, psychiatric autopsies weren't yet dependable and reliable enough that there needed to be improvements to the methodology. Dr. Alexander agreed that 4 out of those 6 limitations applied to this case. Dr. Alexander could not testify to a rate of error, which is the third McDaniels factor, that the rate of error was unknown. The fourth is whether the methodology is generally accepted in the scientific community. Again, there is no accepted methodology for psychiatric autopsies. It's not recognized by the American Psychiatric Association. And finally, Dr. Alexander only conducted his research in the context of litigation. Dr. Alexander testified that he had performed 3 psychiatric autopsies, all of those in the context of litigation. So there's no independent research outside of litigation that would support those methodologies. So for those reasons, the trial court correctly determined that the expert's testimony ought to be limited to their areas of expertise and cut off before they ventured into the realm of speculation. With respect to the Ferguson issues, I'll focus specifically on the video recordings, video and audio recordings. The trial court found that there was no evidence that a video or audio recording ever existed. That's a hurdle that a defendant has to clear before even getting into the Ferguson analysis. The state can't destroy or lose evidence that never existed. And so before getting into the Ferguson analysis, the trial court determined simply that those recordings didn't exist. That finding was supported by the record, and the trial court didn't err by refusing to give an instruction for.
Is this the body cam video? Is that what you're talking about?
That's correct, Your Honor. Yes, and the trial court found that those videos either were never activated or never captured on recording equipment. That there was no microphone recordings, and so because that evidence didn't exist, and because the trial court's factual finding was supported by the record, it did not need to go a step further and determine if there was instruction or penalties for the loss of destruction of evidence that didn't exist.
Was this because the state had failed to what they call flag these recordings to be preserved?
No, Your Honor. The trial court found that the recordings were never generated in the first place, and there was a lot of testimony at the Ferguson hearing, and Your Honors can go back and read that. But what the trial court was tasked with doing was listening to this testimony. There were some officers that testified that they weren't sure whether recordings were generated, some that testified that their recording equipment should have activated if their lights are on, but their lights were off. There was other testimony that the lights were on. There was testimony from an officer that normally his body microphone would record conversations, but he forgot to wear it that day, and he'd forgotten to wear it multiple times in the past. And essentially from this very testimony, the trial court concluded that there wasn't enough evidence to conclude that these recordings existed in the first place. Not that they were destroyed after the state failed to preserve them, but that they were never created in the first place. And so that stopped the trial court's analysis as it should have before getting into an actual Ferguson analysis dealing with what the result or consequence of the state's failure to preserve evidence would be. The other issue with Ferguson is the bags that were placed on Floyd's hands to preserve the gunshot residue. Those bags were neither evidence in the sense of Ferguson and Merriman, nor were they potentially exculpatory. The bags were tools that were used to preserve evidence on Floyd's hands. There was question about whether Floyd's hands would test positive for gunshot residue. According to the state's expert, they were negative for gunshot residue. The bags that were used to cover his hands to preserve that evidence for testing were destroyed. Ferguson doesn't contemplate the preservation of every preservation tool that the state uses to fulfill its duty to preserve evidence under Ferguson. The consequence of that sort of rule, that extension of Ferguson, would be to require the state to preserve everything that might contain trace evidence in a lab, that touches a microscope slide, might touch the inside of a body bag. And that's not what Ferguson contemplates. It contemplates the state actually preserving evidence, which is what it did here by placing the bags over Floyd's hands. But even if those bags were evidence in the sense that Ferguson contemplates, they weren't potentially exculpatory, because all they could have shown is that Floyd did in fact have gunshot residue on his hands. And that would have told us only what we already knew, that Floyd was near a gun when it was fired. Gunshot residue indicates that someone either fired, handled, or was in the vicinity of a gun when it was fired. Obviously, Floyd was in the vicinity of a gun when it was fired because he had a bullet hole in his head. And so even if the bags were evidence that the state was required to preserve under Ferguson, it was not potentially exculpatory evidence because they could not have shed light on any facts that weren't already aware to the court at that time.
Was there any testimony either by the medical examiner or the police officers that these bags are regularly destroyed upon ending up in the medical examiner's office, or they're sometimes kept? I mean, was there any testimony of that?
I don't remember. I don't remember from who, Your Honor. I do recall some testimony about the sort of the standard procedure that these were used to collect evidence and they're destroyed afterwards. But the specifics of that, I'd have to check back in the record. Okay. With defendant also raises an issue about the pill bottles. I'll rest largely on my brief with that issue on Ferguson. The pill bottles just were never collected by the state, and so the state had no duty to preserve that evidence. With respect to prosecutorial misconduct, just to briefly address that, a couple of issues raised in defendant's brief on prosecutorial misconduct, the false testimony from Lieutenant Upton that defendant alleges regarding the location of the bullet wound was actually solicited by defendant on cross-examination, asking Lieutenant Upton repeatedly how he described in his report previously the location of the wound and whether that was aligned with his look at the photos now. So that wasn't testimony that was elicited by prosecutors at all. And as Lieutenant Upton explained to the jury, it was his misperception that the bullet wound was more towards the back of Floyd's head when he first viewed the crime scene, compared to the photographs, especially the autopsy photographs after the wound had been cleaned, that the bullet wound was towards the side of his head above the ear. With respect to the death benefits application, prosecutors did correct that mistake. They admitted the error in court. Officers and law enforcement officers and prosecutors were under the mistaken perception that a form downloaded on the Morton computer was a death benefits application. It turns out that was not a death benefits application. There are some very large insurance terms there, and they admitted that error to the trial court. The trial court struck every record of any mention of death benefits application from the record in the case, and that evidence was never put before the jury. That this was not something that the prosecutors were repeating during trial or accusing defendant of during trial. It was.
So did the jury never hear from the state? Was there never the characterization that it was a death benefit?
No, the state never characterized it as a death benefits application to the jury. By that time, the state had corrected its error and understood that the form that downloaded was a voluntary request for benefits. And so even if there was any evidence of prosecutorial misconduct in the original characterization of a death benefits application, that error was corrected and there was no prejudice in actual trial of this case because the state didn't present that representation of a death benefits application to the jury.
Judge Ogle's point, even in opening or closing, or I wouldn't guess closing, but opening statements, it was never mentioned that this is about collecting a death benefit?
Not to my recollection, Your Honor. Now, there is evidence at trial that defendant was the beneficiary of life insurance policies and that she did benefit from those, but specifically with respect to the form that was downloaded on the Morton computer before Floyd's death, the state was clear that it was a voluntary request for benefits. I'd have to check the record. It may have been brought up by defendant at trial that there was a mischaracterization by police, but that was something that was not a characterization provided by the state at trial. And Your Honors, of course, can review the record and double check that. The record is extensive, but the state corrected that error before trial and made sure that all references to the death benefits application that the state had made previously were removed from the record. And with respect to sufficiency, Your Honors, just to go over some of the facts in the records. Of course, the record is extensive, the trial is long, but the evidence did support the jury's verdict of guilty on first-degree murder. The location and the trajectory of the wound would have made it a very difficult shot for Floyd to shoot himself. It was to the side of the head, but it was with his offhand, his non-dominant hand. Floyd, when he was found, appeared to be sleeping. He had a blanket pulled up towards his chest as he was laid down on the couch in a manner that he did many nights, and slept on the couch and watched TV until late at night. He was shot early in the morning as he would have been about to get up and go to work and get ready for work. The gunshot was through a pillow, which was unusual for a suicide. Defendant appeared calm and unaffected after the shooting. Defendant told police when they arrived at the scene that she called 911 from her bedroom, that she hadn't seen defendant or hadn't seen Floyd when she called 911 because she was scared and heard a gunshot. But she told 911 operators that her husband had shot himself before she had apparently left her bedroom. She washed her hands before officers arrived, which helped explain the lack of gunshot residue on her hands, though there was still gunshot residue on her pants.
Was the washing of the hands, is that speculation by the state, or did she tell the officers she had done that?
I believe she told the officers in an interview with law enforcement after the fact that she washed her hands at some point during the morning between when Floyd was shot and when her hands were tested by gunshot residue. Floyd, again, did not have gunshot residue on his hands. There was conflicting testimony from experts there, but the state's expert testified that there was not significant enough levels for a positive test for gunshot residue, and the jury was entitled to credit that testimony over the defendant's expert who testified that there was gunshot residue, even though the samples provided to defendant's expert were tainted because the seal was broken on that box. Defendant and Floyd disagreed about their future plans. Floyd said that the love was gone in their marriage. Defendant threatened to kill Floyd a month or two before the murder. There was no indication from Floyd's friends that Floyd was suicidal. He had plans for the future. He had retirement and a golf trip planned, and he believed suicide was wrong and would lead to eternal damnation. He didn't leave a suicide note. Floyd didn't shoot or handle guns, and defendant did. And in light of all that evidence and the evidence that your honors will review in the record, the jury's verdict of guilty on first-degree murder was amply supported by the evidence put on at trial. Unless your honors have further questions on issues that I've addressed or haven't addressed, the state would rest on our brief and ask that this court affirm the judgment of the trial court.
Thank you. Counsel, you have your 5 minutes.
I would like to first address the misrepresentations from the record. There is no citation in opposing counsel's brief to his claim today that a telephone call was made from the bedroom rather than from anywhere else in the house. That was pointed out in our brief that there were several representations of purported facts that were not cited to the record and indeed were not in the record. The threat as to which the state's attorney references was a remark made by Ms. Morton to her stepdaughter, whom she raised, that I'm going to kill your father, while the window replacement men were at their house and he was off fishing. So I don't think that every time anyone makes a jesting comment to a family member that we should call the police. And in fact, no one did call the police. The friends testified they had a loving marriage, that they had never heard them quarrel. Even Robert, who lived in their household while he was on parole, had never heard Mr. and Ms. Morton quarrel. Now, I want to address what I think is one of the most egregious misrepresentations that contributes to the allegation of prosecutorial misconduct affecting my client's constitutional rights. This is a small town in eastern Tennessee, Loudon is. Search warrants are public record. Judicial subpoenas are public record. In each and every one of these judicial subpoenas and applications for a search warrant, it is referenced that shortly before Floyd Morton's death, someone in the household downloaded a death benefits application. The fact is, as you will see in the appendix to Ms. Morton's brief, these forms are replicated and documented for you. The title of that form in bold capital letters was Request for Hardship Withdrawal from Retirement Investment Plan. It's not a death benefits form, not by any stretch of the imagination. And it is unconvincing that the state's attorney praises the prosecutor for correcting this error. However, that correction occurred 3.5 years later. In this small community, they were talking about that death benefits application the entire time this case was pending. Ms. Morton was not indicted until 9.5 months after Floyd's death. That's another significant fact. In terms of the confusion of opposing counsel as to whether the bags of evidence from Floyd's hands was to save the bags, whether they had a duty to save the bags or not, the fact of the matter is those bags were implemented to collect evidence, to collect the GSR evidence that in jostling and moving Floyd Morton might fall into the bags rather than fall into space. He says that the dispute between whether or not Floyd had GSR on his hands was simply a battle of the experts. One expert says he did, the state's expert said he didn't. However, the salient point is the state's expert was relying on individual swabbing of fingers and the palm and the back. Never added those GSR elements together to come up with what was on his hand, as the defense witness did. So either Floyd had GSR on all of his fingers, the palm and the back of his hand, or he didn't. The fact of the matter is he did. I would also like to point out for the record that the state waived responding to 4 of the issues in this appeal and has not addressed those issues here today. One of those issues was the Confrontation Clause violation. He also has not addressed that the standard of proof requires him to prove on behalf of the state, beyond a reasonable doubt, that these non-structural constitutional errors did not affect the jury, that they did not influence the verdict or harm the defendant. In his brief, he argues that that's Ms. Morton's obligation to establish that fact. Indeed, it is not, according to the Rodriguez opinion. Once one removes the improperly admitted evidence, all of the hearsay from people who didn't testify at trial, there is no direct evidence of guilt. The evidence is entirely insufficient to support conviction. The cumulative errors, both constitutional, evidentiary, and non-constitutional, overwhelm the paucity of actual evidence. That actual evidence is that a very ill man who had precipitously stopped taking his antidepressant medication was found dead on his sofa after a gunshot was heard. He was shot in the temple. He was not shot in any other location that the state's witness testified to. And I would like to add, too, that the fact that the defense counsel asked this witness these questions does not change the state's duty to correct their witness when he misstates evidence or fabricates evidence. Your Honors, this conviction should be dismissed, reversed and dismissed for insufficient evidence, or in lieu thereof, remanded for new proceedings. The overwhelming evidence is that you can't speculate as to when somebody commits suicide and when they don't. And if we're not going to have speculation, which was the explanation for removing the defense experts, then that removes all of the state's witnesses as well. Thank you very much.
Thank you. That concludes our arguments for the day, and we are ready for Ms. Kraft for recess.
This Honorable Court of Tennessee stands adjourned.
Thank you so much.